Okay, dear students, good morning. So I'll continue with the portions on law, Contract Act. So basically, in the last session, we covered up to on the topic free consent. On the topic free consent, we covered up to fraud and misrepresentation. So if a contract is caused by coercion, undue influence, fraud, misrepresentation. If a contract, that is a consent is caused by, I'll use the word, if consent is caused by coercion, undue influence, fraud, misrepresentation, then the contract is voidable. So this is something very, very important. I hope you have understood this correctly. We have one more thing called mistake, where we are going to discuss today about what are the types of mistake and what is the implications in the contract. Now, mistake can be of two types, I told you. Mistake can be of two types, mistake of law, mistake of fact. And when we talk of mistake of law, we have two types of mistake of law. Mistake of Indian law, mistake of foreign law. Now, if you are entering into a contract by making mistake under Indian law, the contract is still valid. And in case of a contract which is you made a mistake as to foreign law, so mistake as to law, mistake of law. Indian law is valid, contract is valid contract, and you cannot have a valid contract when there is a mistake as to foreign law. Why? With respect to Indian law, we go by the assumption that ignorantia juris non excusat. Ignorantia juris non excusat. Ignorantia juris non excusat. What does it mean? Ignorance of law is not an excuse. Ignorance of law is not an excuse. I hope you all are very much aware of this. We discussed this earlier also. So when we talk of a mistake of an Indian law, it is a valid contract. The contract will continue and you have to correct the mistakes and proceed to do the contract. Whereas if it's a mistake of a foreign law, it's void. Then coming to mistake of fact. Mistake of fact essential to the contract. Essential to the contract. That is something very important. Mistake of fact essential to the contract. Not some mistake. That is something very important to the contract. It can be bilateral mistake. That is, both parties are under a mistake. Unilateral mistake. One party is under a mistake. Now, when both parties are under a mistake, the contract is void. And the contract, when one party is under a mistake, unilateral mistake, the contract is valid. What is a bilateral mistake? If you remember in the last session, I gave you an example. A and B are entering into an agreement where A promises to sell his car to B for 5 lakhs, B promises to buy, and as they are discussing, a car is lost by fire. The car is not available. So there is a mistake as to the subject matter. Mistake as to the subject matter where both parties have made a mistake. They don't even know the car is lost by fire, but they are entering into a contract or agreement. So the contract cannot be enforced. It is void. Whereas if it's one party making a mistake, so one party is under a mistake. No, he is going to a shop and buying something by mistake. The contract is still valid. You cannot cancel the contract. Okay, so very, very important. So mistake of law, mistake of fact, mistake of Indian law, mistake of foreign law. Mistake of foreign law, as I said, it's void. It cannot be enforced in the court of law. So now kindly make a note of this section 20. So section 20 talks about bilateral mistake. Section 20 talks about bilateral mistake. I'll read out what is section 20 talking about. So where both parties to an agreement or under a mistake as to a matter of fact essential to the agreement is void. So in fact the agreement is void. When so we cannot become, you can't even call it as a contract. The agreement is void. So I'll use the word agreement is void. So I'll repeat this. When both parties to an agreement are under a mistake as to matter of fact essential to the agreement, comma, the agreement is void. So very important, and it's basically an erroneous opinion. A mistake is an erroneous opinion as to probably value of a thing, or which is something which is related to existence of a subject matter, etc. Now, when we talk of bilateral mistake, there are few types of bilateral mistake. So bilateral mistake, when both parties are under a mistake, what are the types of mistakes we can make? Bilateral mistake. Mistake as to existence of the subject matter. Mistake as to existence of the subject matter. Existence of the subject matter. Now I give you an example. A and B enter into an agreement without knowing the car is damaged by fire. It's a bilateral mistake as to existence. So I have used the word here, existence. The mistake is regarding existence, and of course what is important is subject matter. Then secondly, mistake as to quantity of the subject matter. Mistake as to quantity of the subject matter. Now, what is the mistake you can make regarding quantity of the subject matter? Now, quantity of the subject matter. A orders to B send one truckload of cement, and so in this truckload can be 1 ton, 2 ton, 3 tons, or whatever it is. That has not been clear. So it's sort of a mistake. So A said small truck, B sent it in large truck. So there's a mistake as to quantity of the subject matter. The agreement is void. So there's no consensus add item, right? So in fact, in the initial classes we discussed about importance of consensus add item, where both parties should understand the thing in the same manner. So if there is no such thing understood in the same manner, so it's void. Agreement itself is void, so it cannot become a contract. Then mistake as to quality of the subject matter. Mistake as to quality of the subject matter. Now quality, you all know that quality varies, and there are different criteria for quality. And for example, in terms of gold, you know what is the quality criteria? It is carat. So you buy a 22 carat gold or you buy a 24 carat gold. So A orders to B one particular quality of rice, and whereas B sends different quality of rice. So there is a mistake as to subject matter which is essential to the contract. So the agreement is void. Here again there is a lack of consensus add item. Then mistake as to price of the subject matter. Mistake as to price of the subject matter. So that could be relating to quantity also. So the price and quantity could be, or it could be relating to quality also, because the price will vary depending on the quantity and quality. So both parties have made a mistake as to price. A ordered some quantity of or a quality of rice for 50 rupees a kg, whereas B has sent it for a price which is 60 rupees. So there is a mistake as to both parties making a mistake as to price, and the agreement is void. Again, in all these cases, what is missing is consensus add item, what we call meeting of minds. There's no meeting of minds. Meeting of minds. And when there's no meeting of minds and they make mistake as to quality, price, quantity, existence, then the contract or agreement itself is void. Mistake as to identity of the subject matter. Mistake as to identity of the subject matter. So A is talking about a car which is willing to sell to B. A has got two cars. A is talking about a white car and B is talking about a black car. So both of them are under a mistake as to which car they're going to sell. So there is a mistake as to identity. Then mistake as to title of subject matter. Mistake as to title of subject matter. Title means ownership. Now A has actually bought a two-wheeler which is a stolen two-wheeler and he is willing to sell it to B without knowing that A himself doesn't know it's a stolen two-wheeler, and B is also not aware that it's a stolen two-wheeler. So A is wanting to sell it to B and B is also willing to buy. So here A is actually not the owner. So title means ownership. When there is a mistake as to title of the subject matter and when both parties are making a mistake, then the agreement is void. So very important, it's called a bilateral mistake. When both parties are making a mistake, it's called a bilateral mistake and the agreement is void. The agreement is void. It cannot become a contract. It cannot become a contract. Whereas in case of unilateral mistake, only one party is making a mistake. So in this case, the contract is valid. Now, very important, what does it mean? So A tells B, I will sell my used car to you, and B buys a car assuming that the car has got an imported engine, whereas the car doesn't have actually an imported engine. A doesn't say so, but B has made some assumption on his own. He made his mistake on his own, assuming that the car is got, let us say it's a global brand, Audi brand, but made in India. But what B thinks, it's an Audi car where the engine is imported from Germany. But it's a mistake of B. It has got nothing to do with A. B should have checked with A. B did not check with A, and he goes ahead and buys the car. Whose mistake it is? It is a mistake of B. So the contract is still valid. I'll give you a very interesting case law. Smith versus Hughes. Smith versus Hughes. In this case law, what happened? I'll tell you. X sold oats to Y by sample, and Y, thinking that they were old oats, purchased the oats, and in fact the oats were new. And it was decided by the court that Y was bound by the contract because it was a mistake of Y and not of X. So very importantly, Y goes and buys old. In fact, in rice also you have same point, old rice, new rice. I don't know how many of you are aware of that. There is something called old rice, new rice. Old rice is good for cooking, whereas not new rice. What is a new rice? Something which is newly, for example, 3 to 5 months old rice is called a new rice. Anything above 6 months generally is called a old rice. Old rice is good for no taste, and it gives you larger quantity when you cook and all that. So people prefer to buy old rice than new rice. Same thing happens in oats. People prefer to buy old oats than new oats. But Y on his own went and bought the oats thinking it's old oats, whereas it was new. So it was a mistake of Y. So the contract cannot be cancelled. The contract is valid because it's a unilateral mistake. There is one party who has made a mistake. So very important, my dear students. Kindly note, unilateral mistake, the contract is valid. There are exceptions here. In unilateral mistake, the contract is void in these two following exception situations. Very, very important. I'll repeat. In case of the unilateral mistake, there are two scenarios in which the contract, exceptions means unilateral mistake, contract is still valid, or rather void. Contract is void. Normally it is valid, but in two cases, in case of unilateral mistake, the contract still becomes. So exceptions, in case of unilateral mistake, the contract is normally what? Valid, but in the following two cases, the contract is void. What are those two cases? I'll tell you. Okay. That is one. It relates to identity of a person. Very important. When you want to go and enter, A wants to go and enter into contract with B, but by mistake, he goes to C and enters into contract. It's a mistaken identity because B and C are look-alike, or B and C have similar name. So let us say a film producer wants to go and sign a contract with A.R. Rahman, but there are two names A.R. Rahman, adjacent neighbors, but they go and enter into contract with the wrong A.R. Rahman. This is more theoretical, but for the sake of understanding, if you are going to enter into contract with the wrong person, it is relating to identity of a person, then the contract is not valid and it becomes void. So normally unilateral mistake, the contract is valid, but in this case, even though it's a unilateral mistake, the contract is void. Secondly, if there is a mistake as to nature of contract, for example, you are going and buying a car or a TV on a hire purchase scheme. You know, under hire purchase scheme, the ownership will get transferred only when the last installment is paid, correct? But without knowing that, you go and buy a TV or whatever under hire purchase system, assuming that as soon as you buy the TV under hire purchase system, you become the owner. You assume so. It's a mistake actually. So here it's a mistake as to nature of contract. Example, hire purchase of a TV. You are under a mistake that no, you thought that the TV you will become the owner. So this is so fundamental to the contract that you made a mistake. So in this case, the contract cannot be enforced in a court of law. The contract is void. So my dear students, unilateral mistake, the contract is valid, but under these two exception situations, the contract is void. Are you able to understand? So I'll repeat. Unilateral mistake, the contract is valid, but in two exception situations, in case of unilateral mistake, the contract is void. What are those two circumstances? One, it relates to identity of the person. That means you are going and contracting with the wrong person. Secondly, it is mistake as to nature of the contract, which is so fundamental to the contract that if you make a mistake, it cannot be enforced in a court of law. So the contract is treated as void. Very, very important. Are you able to make a note of this? So understand this correctly and make a note so that it will be easy for you to follow later. And in case of any doubts, feel free to reach me out. Okay. So kindly make a note. This topic is very important. There are many important things we discussed: coercion, undue influence. We discussed about fraud, we discussed about misrepresentation, all that we discussed, and lastly we discussed in detail about the case called mistake, and hope in mistake also we discussed about different scenarios. Hope you are able to follow that. So let us look at some examples here so that you will be able to understand it better. X beats Y and compels him to sell his house for 1 lakh rupees. So carefully understand this example. X is beating Y and compelling him to sell his house for 1 lakh rupees. Y agrees to sell his house to X, and then they sign the contract for sale of house and receives the payment. Later on, Y wants to cancel the contract. Will he succeed? The answer is yes. Y can cancel the contract later because the agreement was signed by coercion. The contract was by coercion. It's a voidable contract and the free consent is not available, it's missing. Consequently, Y will have a right to cancel the contract. Not only that, in coercion, I use the word, it should be forbidden under an act forbidden under the Indian Penal Code. So in this case, it's an act, beating somebody is an act forbidden under the Indian Penal Code. So since it's an act forbidden under Indian Penal Code, you have the contract is voidable at the option of the affected party. So this is one good example about coercion. And similarly, you can think about an undue influence and misrepresentation and fraud. And so in your book, you may have some more examples also. Kindly go through that. Okay. And okay, I'll give you one more example here. X offers to sell his black horse to Y. Y agrees to buy the horse, and it turns out that the horse was dead at the time of bargaining, though neither party was aware of it. And is this agreement valid? The answer is the agreement is void because both parties are under a mistake as to subject matter, which is so essential to the agreement, and this is regarding existence of the subject matter. Both parties are under a mistake as to existence of the subject matter. Consequently, there cannot be a contract. The agreement itself is void. And so these are some few examples which I thought it will help you to understand the whole aspect of coercion, undue influence and all that. So with this we are completing this topic on free consent. So in the continuation of it we will be moving on to the topic called legality of object and consideration and agreements supposed. So void agreements, etc. So the other topic we are going to continue now is void agreements. Void agreements and legality of object. Because for every contract, the object should be legal and legality of consideration. We also discussed that consideration should be lawful consideration or legal. Legality of, these are all actually common topic only. Then agreements opposed to public policy. Agreements opposed to public policy which are declared to be void, opposed to public policy. And we have void agreements. Under the Contract Act itself, there are few agreements which are referred to as void agreements. So let me explain this topic to you. Legality of object, legality of consideration, agreements opposed to public policy, and we have something called void agreements. So that's the other topic we are going to cover, and What are the circumstances under which an object or consideration is deemed to be unlawful? Now, very, very important. Unlawful agreements. Unlawful. What is the difference between illegal and unlawful? We need to know. Illegal versus unlawful. Now, very, very important. Something which is opposed to public policy is illegal. Something which is opposed to public policy is illegal. So, to give you an example, buying and selling stolen goods is illegal because opposed to public policy means not in the interest of the public, not in the interest of the public. Something opposed to public policy. So, for example, dealing in stolen goods. Dealing in stolen goods. Now, there is something called unlawful. Something which is against law. There is a law, and law means there is an act and somebody is acting against the law, then unlawful. Now there are certain acts for which there is a law, and if you do something against law, that becomes unlawful. But there are few things for which there is no law, at least presumably, and they are referred to as illegal because they are opposed to public policy. That means opposed to public policy which is against public welfare. So this is against public welfare. Against public welfare. Against public welfare. So example I gave you, dealing in stolen goods. Such agreements are void. Such agreements are void. Unlawful agreements, any agreement which goes against law. There is a law which doesn't allow you to export onion, but you are going and exporting onion against the law. Then such agreement is void, and this is an unlawful agreement. So very importantly, under the Contract Act, the object and consideration of an agreement must be lawful. Otherwise, the agreement is void. And according to Section 23 of the Indian Contract Act, the consideration or the object of an agreement is unlawful in the following cases. So let us refer to Section 23. So Section 23 talks about agreements which are unlawful. The consideration or object of an agreement. The consideration or object of an agreement is unlawful. Or object of an agreement is unlawful when? One, if it is forbidden by law. If it is forbidden by law. If the law doesn't allow you to do so, then the consideration or object is. So can you pay consideration in the form of no, what you can call fake notes? No, because it's forbidden by law. So consideration is unlawful if you pay through fake notes, if it's forbidden by law. Secondly, if it defeats the provisions of any law. If you do something, if it defeats the provisions of any law. That is, it goes against law. That's the basic meaning of it. If it defeats the provisions of any law, then also consideration or object is unlawful. If it is forbidden by law, the law doesn't allow you to do so. Secondly, if you do so, it will go against the provisions of law. Thirdly, if it is fraudulent. If it is fraudulent. As I said, buying and selling of stolen cars, something like fraudulent, and you cannot do so, and that is also void. And if it involves or implies, if it involves or implies, if it involves or implies injury to the person, injury to a person or property of another, to a person or property of another. So an agreement which involves or implies injury or to a person or property of another. A and B enter into a contract to go and damage the property of C. A and B enter into an agreement to go and damage the property of C. Is it a valid agreement? No, because object is unlawful. It is void. So if it involves or implies injury to a person or property of another, the agreement is void. And if the court regards it as immoral, if the court regards it as immoral, it as immoral. You all know what is morality. So some act or object of an agreement which is immoral or opposed to public policy. Something, as I said, opposed to public policy means against public welfare. So if an agreement is something which is opposed to public policy, it is void. My dear students, the object of an agreement is such that the court regards it as immoral. Any immoral agreements is void or opposed to public policy. So in both these cases, the agreement is void because of two reasons, the consideration or object of it is unlawful. So any agreement, the consideration of or object of which is unlawful is void and it cannot be enforced in a court of law. It doesn't even become a contract. So very, very important, my dear students. There are these 3-4 points. Kindly carefully understand this, 5 points rather. So consideration or object is unlawful under section 23 if it is forbidden by law, if it defeats the provisions of any law, if it is fraudulent, and if it involves or implies injury to a person or property of another, and if the court regards it as immoral or opposed to public policy. Okay, so I'll stop this session here. So kindly go through this whatever available in your book and get back to me for any doubts. I'll catch up with you in the next class with the other aspects.